Now coming to the Waqf Act. See, in the book, very esteemed Mr. Anand Ranganathan has highlighted various provisions of Waqf Act. But I will also tell you certain various provisions of Waqf Act which are very, very draconian and which makes us feel that we are not second-class citizens, we are 8th, 10th, 15th class citizens. Section 4, 5 and 6 of the Waqf Act. There is a survey of Waqf properties which happens in every 10 years. Do you know that the money of that survey is borne by the state government through taxpayers' money under Section 8? Now I ask a question to myself, that is there any provision where the properties of Hindu temples or of Hindu religion is monitored by the state government and the money of that survey is borne by the expenditure of state government? There is no such provision to my knowledge. And I asked this on national televisions to various legal luminaries, no answer has come. The second most draconian provision under the Waqf Act is Section 40 subclause 1 and Section 40 subclause 3, where the Waqf board can declare any property as Waqf property. And the person whose property is declared as Waqf property, he will not be even informed that his property has been declared as Waqf property. And if the property is of a trust or a society, the society or the trust will not get the communication that their property has been acquired as the Waqf property. The registrar of the trust or the society will get the communication. And we know what happens in the office of registrar and the registrars of the societies. All these communications are just thrown away. And after 1 year, that order will become final if you don't challenge it in the Waqf tribunal. So ultimately, because of this mechanism, the Waqf is the third largest owner of land in the country after defense and railway. And these are the statistics of 2008 by Andhra Pradesh High Court. We are 15 years down the line. If anyone against checks up, I think it will be the first or the second. So this is Section 40 for you. Then for us, if someone encroaches upon our property, what is the law? If you will ask any lawyer, he'll say, go and fight a case in the civil suit, in the civil court by way of a civil suit. For Waqf, the provision is under Section 53 and 54. They can issue a direction to the district magistrate and the SSP to remove the encroachment and submit a report under Section 53 and 54. No such provision is there. Forget about Hindus, for any other class of citizens in this country. Then apart from that, there is Waqf tribunal under Section 83 and 85, where the members of Muslim community will be heading the tribunal, will be a part of the tribunal. So ultimately you are asking me to go before a Sharia court. So you are the judge, jury and the prosecutor. Then apart from that, I want to ask this question to everyone with lot of sense of responsibility, that I have not come across any law till date through my legal learning that any pujari, priest, Shankarachar, Mahant, Pithadishwar has been declared as public servant in this country. None I have come across. But under the Waqf Act 1995, under Section 101, the members of the Waqf board and their mutwallis and in the Waqf deed, everyone is declared as public servant. So it means that even if you touch them, it's an offense under the IPC under Section 27. Then apart from that, it's not the end of the story. 2 more sections I want to point out. Then
बसकर पगले रुलाएगा क्या?
Then under Waqf Act 1995, Section 107 is there. Meenakshi ji is here. In Ram Mandir's case, the very age-old concept that Hindu deity is a perpetual minor and it can come to court at any point of time is diluted by the Supreme Court. The Supreme Court has held that if deity wants to come to the court and if there is no shibaya, then only they can come and Limitation Act will not apply to them. But under the Waqf Act 1995, the Waqf is exempted from limitation, meaning thereby you can come to court at any point of time, you can declare any property at Waqf property at any point of time. And the recent example is the temple in Tamil Nadu. The recent example is Taj Mahal. We used to say Taj Mahal is Tejo Mahal. We used to be treated so badly by the left wing historians as well as left wing whatever you can say. But Taj Mahal has been declared as Waqf property in 2005 by Sunni Central Waqf Board. The Archaeological Survey of India is in appeal in the Supreme Court. And there are so many declarations as Waqf by the Waqf Board. So and Limitation Act does not apply to them. So the point is, for Hindus, You have to come to court within a particular period of time, 3 years or 12 years. After that, your remedy is barred. But for them, remedy is not barred. You can come to court at any point of time. Waqf board is given the status of a parallel government. If you want to file a case against the government under CPC, under section 80, everyone will be knowing here, you have to give a notice of 2 months. Under the Waqf Act 1995, if you want to file a case against the Waqf board, you have to give them 2 months prior notice, just like parallel government. And the last and not the least, section 108 of the Waqf Act. Now, I'll tell you this story. When India was partitioned, the people who left, the Muslims who left India and they migrated to Pakistan, all those properties came within the purview of Administration of Evacuee Properties Act 1950. And the central government became the custodian of those property. That all those properties, where Hindus were tenants in all the properties of the central government, they were believing that they will be given ownership of those properties. Rajiv Gandhi government in 1984, by amending the Waqf Act 1954 and by introducing section 66H, H for Himachal Pradesh, gave all those properties to Waqf board. And today, the Hindus are, in earlier they used to pay rent of 100 rupees or 300 rupees, so it didn't matter to them. Now the rent is 1 lakh, 2 lakhs. Punjab, Haryana and various other states of this country are burning because of this issue. And same provision you will find place mentions in section 108 of the Waqf Act. Now, if you compare this, so Waqf, Waqf is there. Now, if you compare this Waqf with places of worship act, you have blocked an entire civilization from approaching the court. On the one hand, kindly see the dichotomy. On the one hand, you give the power to the Waqf board to declare any property as Waqf property. If someone is aggrieved, go to Waqf tribunal, High Court, Supreme Court. On the other hand, if I want to say that Kashi temple is a temple of a Hindu religious identity, they say, no, you can't contest the case in the courts of law. From past 33 years, me and my father are contesting this case on a very trivial point that please allow us to lead evidence. It's now because of the awakening of this civilization that we are getting this opportunity. But from past 30 years, the case didn't move forward. It was pending in Allahabad High Court from 1997 till date.
Yeah.
It's another matter we researched. Then we filed a separate suit and we got success in that suit through a very narrow legal interpretation that religious character needs to be determined in the suit. But the point is that you are blocking a civilization from filing a case in the court, and on the other hand, you have all the powers to declare anything. I think this is very, very draconian, and someday we all have to collectively stand against these two legal statutes.